This is our Law, Politics, and Media Spring Lecture Series, and we are today having the 7th lecture in our series. Our final lecture will be next week. This lecture is co-sponsored by IJPM and the Tully Center for Free Speech, which is directed by this man right here, Professor McDreamy, the man who had me at hello, Roy Gutterman. These lectures are also part of a class on law, politics, and media that is co-taught by Roy, myself, and Lisa Dolak, professor here at the College of Law. Today's lecture is entitled The Terror Courts by Jess, Bravin, who is Supreme Court correspondent for the Wall Street Journal. He covers the Supreme Court beat for the Wall Street Journal. He's previously the journal's United Nations correspondent and also editor of the weekly at the Wall Street Journal, published regionally in the West in California. He's received the American Bar Association's Silver Gavel Award for coverage of law and terrorism after 9/11 and the UN Correspondents Association Elizabeth Nuffer Memorial Prize for reporting on the International Criminal Court. He was educated at Harvard and Berkeley and is Regent Emeritus of the University of California. He's contributed to several books, including Crimes of War 2.0 and Violence in America, an encyclopedia. And his first book was Squeaky, The Life and Times of Lynette Alice Fromm. His latest book, and it's going to be the subject of our discussion today, is called The Terror Courts, which was recently published by Yale University Press. There's getting a lot of buzz around this book, and in fact, just gave a radio interview today, shortly before coming to this classroom. This book, Terror Courts, is based on a decade of reporting that Jess Bravin has done on military commission prosecutions at Guantanamo Bay. Before I welcome Jess to the podium, just a few remarks about how we're going to proceed today. Jess thought it was best, and I agreed, to try to get to a conversation with all of us as soon as possible. So he's going to begin by giving some orienting remarks. Then I think there'll be a few questions by the faculty just to kind of prime the pump and set the stage. And then we will move to Q&A with the audience. So usual practice is to have kind of a more conventional lecture followed by Q&A, but we're going to be staging this more as a discussion, which I think will work well with not only the timeliness of the topic, but also the many facets of the topic. It would allow people to have their questions of interest addressed. We will go until 5 o'clock, and then at that point we will conclude and have a reception right here in this room. So the food will be wheeled in quite dramatically with a lot of fanfare. This is what Nicholas lives for, this moment. And I invite you to stick around and continue the conversation over food and drink. Without further ado, please join me in welcoming Jess Bravin.
Well, thank you, Professor Bravin, and thanks for having me here to escape the stifling heat in Washington, which just turned 80 degrees yesterday. So it's nice to finally cool down after that lengthy half-day heat wave that Washington had. Yes, this is here in fact is the book with the dramatic cover of The Terror Courts, and I thought I would sort of talk about how I got onto this topic and something about what is going on now at Guantanamo Bay in the 2 courtrooms there, and how that's developed over the past decade, and then have a conversation, because there are many overlapping and confusing things about the detention and trial regime that the United States has established at Guantanamo Bay, and it also has some relation to other things in the news. A lot of people are curious about the relation between the drone warfare program and the prosecutions and detentions at Guantanamo, and those sorts of things might be on people's minds here. But particularly because it's a law class, I thought that there might be questions that are more specific to the legal aspects of the U.S. project at Guantanamo and how those have played out so far in the federal courts, and how they might play out in the future, because there will likely be further cases involving what goes on at Guantanamo Bay. But to start out, and I told this to those of you who lost the lottery and had to have lunch with me. You may have heard this earlier. When I was in law school in the 90s, unlike my classmates, I took small courses, which meant useless courses in things like international humanitarian law and habeas corpus and so forth, in part because I found those things really interesting, and also because they would help prevent me from having to work in a law firm, since there's really no paying clients who are interested in things like that. And since I really was approaching law in a more, general or intellectual or irresponsible, I think that's probably the most accurate way to put it, way, those were the things that I pursued. I then joined the Wall Street Journal right after law school. I'd done some work as a journalist in between college and law school, so I had a bit of background in it, and covered legal affairs for them in California, then edited our then weekly section of California News, and then moved to New York to become a national legal writer in 2000. In 2000, I sort of, by happenstance, happened to be in Florida in November, when I heard something on the radio about some issue with the election that year, and I called in, reported I was there, and was sent to the Palm Beach courthouse, and ended up working on this election story in 2000 that resulted in the beginning of the Bush administration. And it seemed like that was sort of the biggest story ever. But the following year, on September 11, 2001, was actually the first day of my vacation that I was supposed to be going on. I had a ticket. I was actually planning to fly to Greece that day, and got up and turned on the radio for the weather report and heard something about a fire at the World Trade Center. And so I looked out the window, which I could see from my walk up in Brooklyn, and there was smoke coming out of the World Trade Center. And so to get a better view, I turned on the TV, like people across the country, and saw the towers fall, and lots of things immediately changed for people who were in New York. Some of you, probably were there in a younger iteration. And for the first month after 9/11, I was on the ground in New York covering the way things had changed in the city. And for the Wall Street Journal, really more than any other news organization, it was really transformative, because our newsroom was across the street from the World Trade Center in the World Financial Center, and it was destroyed in those attacks. And so we had basically no headquarters. We had satellite offices, and that's how the paper was put together. The following month, I was sent down to Washington to cover the legal aftermath of 9/11. And that was legislation that became eventually known as the Patriot Act, and all kinds of other things that were going on in the government and the Congress, the administration, not so much in the courts at that point, regarding how the United States was going to respond. And when I was there doing things reporters do, just bothering people basically, trying to find out what was going on, I heard about this project in the works to create military commissions. And to me, it was, those were things that I had actually read about in law school, but they were things that I thought of as some kind of dormant, some antique, and yet here it seemed that the Bush administration was very serious about resurrecting a military commission. And one thing became evident, incidentally, is that the terminology was very confusing, because when most people, at least prior to 9/11, thought of a military commission, they thought about the act of becoming a military officer, which is when you are commissioned as an officer, you're a military commission. But this, of course, is a commission in the sense of a panel, but it's not a commission in the sense of the people who run your local county or library or whatever. It's a commission in the sense of a tribunal. And so all this nomenclature ends up being very confusing in this field of study. But the last time the United States had done this type of trial, which was historically a sort of an ad hoc special military court for people suspected of violating the laws of war, had been right after World War II, when the United States conducted hundreds and hundreds of these trials in the Far East and in Europe. There also were related panels, such as the famous Nuremberg Tribunal, and if you wanted to learn more about that, I can see that the film made by the Schulbergs is going to be playing here in Syracuse. So I would encourage you to go and see it when it plays, because it actually plays very much into the story of military commissions today as the example that hangs over much of what people who are working on that project are doing. But, for me as a legal reporter, it was like, it was basically it was the legal equivalent really of a sort of Jurassic Park, like taking the DNA of an extinct species and resurrecting it and giving it flesh and blood in our own time. And it seemed to me like really the most exciting legal story coming out of 9/11, at least for me. And I made a point of trying to follow it as it progressed. And it progressed very slowly. It was years before there were the first hearings held in any of the cases at Guantanamo Bay in 2004, and I was there for those. And along the way, newspapers cover history incrementally, and there are different kinds of stories, short daily stories about something that happened, and sometimes little scoops, sometimes bigger scoops, sometimes big news features that we'd put on the front page that are like sort of magazine stories, different ways of getting at what's going on. And as this moved forward, it really became clear to me that what we were looking at was not so much a Nuremberg for the 21st century, but more of almost a looking glass form of justice, in which things that normally we assume, in fact, we probably assume them so much that we never even think about them, were working in a very different way through this apparatus being established at Guantanamo Bay. And I'll give you one very, very obvious example. Normally, when someone's accused of a crime, they bring the defendant to the courthouse where everyone is waiting to see him. At Guantanamo, it's the other way around. The defendant stays put, and the entire court gets on a plane chartered by the United States government and flies to Guantanamo Bay, including the prosecutors, the military judge, the defense lawyers, the interpreters, the paralegals, the witnesses, the victims' families, the press corps. All these people get on a plane that the United States charters for hundreds of thousands of dollars and fly there and conduct the court for the defendant who stays put. And you can, if you have a morbid imagination, keep in mind that there was a mechanical malfunction on that plane in February, and it had to make an emergency landing in Miami. So, there things could happen that would derail this whole project entirely. And I've been at times at Guantanamo where we've been stuck because the plane was missing a part and it couldn't leave. So we were just sort of stuck there. And you'd see, like, on the chalkboard in the press room, sort of a list of things to get. Cereal, coffee creamer, airplane part, would be listed as what people would hope to pick up. But there's more than that in this kind of looking glass quality. One is that, if in criminal procedure, usually things start with, say, a crime, and the police arrive and they look through the evidence, and the evidence points them to a suspect who they go and try to arrest. At Guantanamo, it worked the other way around because prisoners were sent there with very little screening by the United States. So there were the first few hundred people who were sent there. The United States knew very little about them, except they had already been classified as being bad guys. So when the criminal investigation team for military commissions showed up, they were basically told, here are your suspects, go find out what they did. And that was really the job of the military investigators who were assigned to this project. Then, normally, when crimes are prosecuted, the bad deeds are evaluated against an existing code book where you have the elements of a crime spelled out, and the question is, did the suspect commit these deeds establishing this violation? But it was really unclear, since military commissions were designed to effectuate convictions rapidly, the code book was designed the other way around. As investigators and intelligence agents developed information about the prisoners they had, crimes and elements were drafted around the evidence that they had collected, so they would be able to have triable offenses by these military commissions. So these are some examples of how the process was inverted. And if you follow the news starting the week of April 22nd, when pretrial hearings resume in the 9/11 case, you'll see that once again, a lot of the presumptions of a normal trial are inverted. For example, typically, someone is accused of a crime. Typically, they don't want to get punished, so they'll deny that they did it, and there'll be a burden for the government to prove that they did it and then punish them when they're sentenced. But in the 9/11 case, the 5 co-defendants, they are fanatics, and they're quite proud of attacking the United States, and repeatedly in court talk about their hatred for America and all the bad things Americans have done, and have repeatedly claimed responsibility for 9/11 and many other attacks. They are not claiming mistaken identity or insanity or anything else. They are quite, they view themselves as warriors in a holy cause, and there is no mystery about at least their willingness to claim responsibility of what they are accused of having done. And in fact, they tried to plead guilty before, but they couldn't because the rule book at the time in place for military commissions had been basically Xeroxed from aspects of the Uniform Code of Military Justice, which is designed for the U.S. service members. And it has in it a lot of elements that are specifically designed for U.S. service members, including protections against some of the hazards that might apply in a military justice context that don't apply in a civilian context. And one of them is a protection against being pressured into pleading guilty by your superior officers. That's not an issue that we typically have in the civilian courts, but in the military, which is a top-down organization, there are procedural elements in the military law codes so that a lower-ranking soldier will not be in a position of further offending his commander. So, for that reason, relatedly, appeals of convictions in court-martial are automatic, right? So that way, a soldier can't be pressured not to appeal, or can't feel maybe he'll please his commander if he doesn't appeal. Appeals are automatic to military criminal appellate courts. Another similar type provision is that you can't plead guilty to a capital crime. So the United States wants to execute Khalid Sheikh Mohammed and the 9/11 co-defendants. They want to plead guilty and be executed, but when they tried to plead guilty, the judge froze because he didn't know what to do when someone tried to plead guilty to a capital offense, and he asked that the issue be briefed. So they're quite willing to do that. What then is the purpose of this trial, or what is the thing that we're going to learn in this trial? What is actually on trial? Well, the defense attorneys, at least on background, will concede that guilt and conviction is a foregone conclusion. And the entire defense plan seems to be based on mitigating circumstances. Now, I'm sure people here have all had, criminal, they all know all this mitigating circumstance. Well, anyway, more or less. Well, mitigating circumstances, in other words, when someone is convicted of a crime and there's going to be a sentence, generally there are aggravating circumstances, things that make it even worse than just being convicted of the plain vanilla version. And then there are aggravating, or rather mitigating circumstances that make it less culpable. And one of the ones that, and the one that plays into these trials is government misconduct, because when the government breaks the law to obtain a conviction or does things to criminal suspects that are illegal, or in one phrase that Justice Frankfurter used, shock the conscience, then the government can be punished when it comes to sentencing, and they can be punished either by having charges dismissed, or they can be punished by having sentences reduced to reflect the lack of moral authority or the forfeited moral authority that clouds the government's case. And so the 9/11 trial is going to end up being actually a trial about what the United States already did to the defendants before they were charged with crimes. And these 5 defendants were all held in secret CIA prisons and were, according to their attorneys, tortured and in lots of ways, and we can talk about what those were. But the defense position is going to be that government misconduct and its mistreatment of these prisoners should, at the very least, take the death penalty off the table. Now, we don't know how that will come out. The government will have arguments against it. But reflecting that fact, the lion's share of pretrial litigation has been not about the government's efforts to get stuff into court. It's been the government's efforts to prevent stuff from getting into court. And the government has undertaken extraordinary efforts to prevent public disclosure of what it already did to the defendants. And that has been a subject of continuous litigation and will be later this month. In fact, the government has gone so far as to say that anything the defendants themselves utter is presumptively classified. And that is an unusual position because normally the only people who are bound by classification rules in the United States under U.S. law are people who work for the government and have signed agreements agreeing to be bound by it. In other words, if you are a soldier or an intelligence agent who chooses to work for the government and deal with classified material and obtain a security clearance, you can be criminally punished for disclosing classified information under some circumstances. But I can't. And if I had that same information, because I have no agreement with the government, if I should happen to obtain information that is classified, it's not my job to keep it secret as a reporter. And this, of course, goes for anyone who's not a reporter too. If you have So classification rules apply to people who have chosen to accept those conditions as part of working for the government. Well, the 5 co-defendants in the 9/11 trial did not work for the United States government and did not agree to protect its secrets. So the government takes the position that they were participants in a classified program. And as participants in the program, they are bound not to disclose the details of that program. And the defense lawyers mocked that as saying that's like saying that President Kennedy was a participant in the Kennedy assassination. They don't like that model. So right now, though, we are in a situation where whatever these defendants say is presumptively classified, and there have been moments where the sound feed to the spectators' gallery at the 9/11 trial has been cut, and subsequently we've learned it's because a certain word was uttered. Sometimes that word has been torture and other related words. And the significance of this prior government misconduct is obvious in this courtroom, not so much by who is there, but by who isn't there. And that is because the courtroom was designed specifically for a joint trial of the 9/11 defendants. And there are 6 rows for those defendants. There are only 5 defendants. Where is Mr. Number 6? Number 6 is a guy named Mohammed al-Qahtani. Mohammed al-Qahtani, or as he was known in the Pentagon as 063, was someone who a lot of evidence indicates would have been the 20th hijacker on 9/11. And if you're familiar with that attack, there were 4 planes that were hijacked. There were 5 hijackers on 3 of those planes. There were only 4 of them on one of the planes, and the assumption had been there was supposed to be a 5th guy on that plane that crashed in Pennsylvania. There is evidence pointing to this guy, Mohammed al-Qahtani, as that missing 5th guy or 20th guy, depending which group you are counting him in. And he was listed among the 6 co-defendants who are going to be charged, but the convening authority of military commission, the chief administrator under the Bush administration, dismissed all the charges against him because she said, we tortured him, and therefore it would have been illegal to prosecute someone who had been tortured by the United States under those conditions. And she was asked about the other 5 co-defendants. Well, what about them? And she said, well, I don't have their records because they were held by the CIA. Mr. Qahtani was held by the Department of Defense, and she was a Defense Department official, so she had access to his records. The CIA prisoners, she didn't have their records. So she said, I don't have their records, but I assume torture, is what she said. And those cases are the ones going forward. So the point really is that the interrogation system that the United States established right after 9/11, that was really apparently discontinued by President Obama, or perhaps even earlier by President Bush after it was disclosed, is continuing to have legal consequences today for these proceedings at Guantanamo, and how they will play out ultimately we don't know. So let me do one more bit of orientation, and then I will leave it to you guys. The basic history, incident, of military commissions, just to give you the chronological framework, was that on November 13, 2001, President Bush signed something called a military order, which borrowed some language from a set of orders that President Franklin Roosevelt issued in 1942, authorizing a specific trial of 8 Nazi saboteurs who were captured in the United States after one turned in the others. President Bush's order, which was the one I heard about when I was in D.C. in October 2001, that came out, it borrowed some of that language, but instead of being limited to a specific trial of 8 named individuals, it was an open-ended order going forward forever, in which any person not a U.S. citizen who President Bush designated could be tried in this new system outside any existing legal framework, and who such a person would not have access to any state, federal, foreign, or international court. All the rules of evidence and procedure known in the United States were not practicable, the president said, and so forth. So they would all operate under this new system. That was challenged by one of the detainees, and the Supreme Court agreed that the president had exceeded his authority in purporting to divest these individuals of any rights. And in 2006, Congress then responded by authorizing a modified form of military commissions that provided some rights to defendants. Then Senator Obama voted against that law and criticized it and criticized the way it functioned. When he took office in 2009, his administration proposed some changes to make military commission procedures less unfair, and so he considered them good enough to continue. And so that is the version of these trials that we currently have, a system which has been revised twice since the original one, and yet it sort of, there's a lot of mist around what exactly these things are and how they are similar and how they are different from current federal courts and courts martial, and that might also be something to talk about. But we are now in this third version. All the people who have been charged or are expected to be charged were all captured before 2004, and and it's unclear if anyone else will ever be added to this list. Just this week, there was a recently apprehended person, Suleiman Abu Ghaith, who is, we're told, is Osama bin Laden's son-in-law, was arrested in Jordan and brought to the United States and charged in federal court. A number of some Republican members of the Senate were very critical of that decision. There have since been several other foreign terrorist suspects who were brought to the United States and charged in federal court. So right now we don't know if the military commission system at Guantanamo will be a sort of like a kind of a legal Superfund site where they're trying to clean up this mess that was left there, or whether it is going to be a part of the U.S. Counterterrorism arsenal moving forward. That's one of the unknown elements about it. So there's a scintillating introduction to the topic of military commissions.
I wonder if I could start with a question again. You talk about what your relationship has been with the government and the military, and you've been covering these commissions for 10 years, and it seems like there's often efforts by the government to control the flow of information or altogether suppress it. As a journalist, you're trying to seek this information. How is that work? I mean, is this an adversarial relationship, and what's the nature of that adversarial relationship? Is it a collaborative relationship? And I mean, there are different dimensions to it. I wonder if you could talk about both.
Well, the government is a big entity, and it's not a monolithic entity, and so there are different agendas that different people who work in different aspects of this stuff have, and so the official position of the military and the government is that they are 100% transparent about everything they do, and everything that is appropriate for the public to know is being disclosed. And that's what they would say. In fact, if you go to the Military Commission's website, mc.mil, you'll see that transparency is one of their 3 mottos. And under that, you can click down and read the motions that call for everything the defendants can say to be secret and so forth. So, so there is a sort of, there is on one level, on the official level, there is just a constant tug of war over what they're going to disclose and what they're not going to disclose. And they do have certain methods of making information available. They give press conferences, they give out briefings, they make an effort to help you know what they want you to know. When it comes to things that they don't want you to know, there are different ways to pursue that. The most efficient way is you just try to meet a lot of people and make a lot of phone calls and look through documents and look through clues and evidence. And there are a lot of people who work in these fields, and part of it is just the kind of sourcing you would do anywhere. And there are different points of view within the government about how certain things should be done. There are also some of these are quite clear. For instance, in military commissions, there's a defense. The defense side, they're not part of it. They work for the government. They're part of this. They seem to follow the absolute bright line requirements of what they can and can't say, but there's a lot of stuff that's sort of unclear, and people who are on the prosecution side or people who are in the, working for the administration directly, they will stay very, very clear of that line. They will stay, there are many things they just won't go into at all, while for the defense, whose main interest is discrediting what the government is doing, they will do everything possible to, point you towards things and give you clues. And so that's one thing. Then, of course, there's actually a formal way. One has been, been meetings with high-level officials in the government to complain about policies and ask for changes. And some of those sometimes they have responded and made changes. And then there's litigation. About 14 media organizations, including ours, are suing the government over secrecy rules, saying that they're illegal. And so they're, these things. How would the military put it? It's like a multimodal whatever. There are a lot of angles.
Another question. You wrote a piece, I think it was in 2007, about Colonel Couch, who was in a position to actually prosecute, and ended up withdrawing from prosecution because he felt that he couldn't, as a moral matter, continue, given that evidence had been extracted through intense interrogation. Has it reached a point where people with moral objections are all sort of shaken out of the system now, and everybody there is fine with it? Or, how often do you come across people like Couch? He seems like an extraordinary individual in many ways. Is everybody else just sort of saying, this is my job? Or, what's your sense of how people in the system are proceeding? Couch, let's see a photo of him in here. He's really the main character in the book, and here he is. And actually, it's really not a law book. It's much more of a narrative about what's actually happening in these cases. And Couch turned out to be, and he is one of these government officials who was actually authorized to talk to me. I don't know why, but he was. And he had been involved in many of the most serious cases at Guantanamo Bay and had serious misgivings about many of them. And the one that you're talking about was the one that was the focus of that feature, The Conscience of the Colonel, in which he's a career Marine. He had been a pilot, became a lawyer after the first Gulf War. They had a reduction in the number of pilots, so he had to find something else to do, and he became a lawyer. I guess nowadays it goes the other way, right? There are too many lawyers, so people here might be going to flight school. So he and one of his flying buddies, Michael Horrocks, who had left the Marines, became a commercial pilot, was one of the victims on 9/11. He had been co-pilot on United 175, which was crashed into the South Tower of the World Trade Center. So Stuart Couch had some personal reasons for wanting to go after terrorists. He had the patriotic reasons we'd assume a career military officer would have.
And if you are a lawyer in the military, this looks about as close as you could get to the front lines of dealing with terrorists. Yet he found that again and again in different cases, they had been damaged or ruined by either political interference in decisions or by misconduct in interrogations and detention. And the case in particular, the most, I think, dramatic one that I talk about in that story and goes further in the book, involves somebody who you can look up in the 9/11 report, a guy named Mohamedou Ould Slahi. Slahi is from Mauritania, which is in North Africa, and the 9/11 report lists him as the recruiter for the notorious Hamburg cell of hijackers, including Mohammed Atta and others that hijacked one of the planes. And Slahi was arrested in Mauritania after 9/11 and eventually brought to the United States, or rather to Guantanamo Bay, he was someone who Couch was assigned to prosecute. And the story goes that they weren't really getting much. I mean, a prosecutor in this world at the time didn't have any interaction with a prisoner. He would just get summaries of interrogations, and they'd just be, for Couch, kind of, very bland. Nothing going on here, nothing incriminating. In fact, initially he thought that Slahi was involved in the Millennium Plot. I don't know if anyone remembers that, but this had been a foiled plan to blow up Los Angeles airport in 2000, at the turn of the millennium. And then one day, the intelligence summaries he gets start showing a lot of information, and Slahi starts singing like a canary, and something seems kind of weird, like what Couch wants to know what happened, because as a prosecutor, he's expecting that his whole aim is going to take him into a courtroom at some point. And if he is going to be introducing evidence like inculpatory statements by a defendant, he's expecting the defense lawyer is going to start asking questions about, well, where did those statements come from? How do you know he said that? Who said that? Is that hearsay? Where is it coming from? And so he wanted to know about those interrogations, and he couldn't get anything directly from the intelligence people. So he and his investigator, another NCIS agent, basically had to run an intelligence operation on U.S. intelligence to figure out what was going on in the Slahi case. And they uncovered this extremely disturbing, months-long sequence of what Couch concluded was torture, which it was great as a narrative topic, because in one sense, it worked. I mean, the stuff the guy said was what Couch was able to corroborate. I mean, it was largely accurate information, but the source of all of it was a brutal and humiliating sequence of methods that Couch decided was not only illegal, but also immoral and un-American, and made it impossible for him to bring charges. And he did not resign from commissions, but he's told his superior that he could not bring charges in that case, and he laid out a memo explaining why, and asked that it be sent upstairs in the Pentagon, and it's unclear if it ever went any further. Couch did wrestle with what he should do in these situations, and he also had the virtue, in my view, maybe not the view of like some of his friends, of being quite a talker. And he talked over his dilemmas with other people, including other superiors in the Marine Corps who had different missions. And his the advice that he received generally was that his duty should be to stay and keep pointing out what's wrong and not get along, but a good officer is going to do the right, sort of platitudinous thing, but I meant it, stay there, and if something's going on that you think is illegal or unethical, write a memo, send it to the right people, create the record, and stay the course. You don't quit. And so that's what he did. And he is not the only one. There were many, I think, very principled people who were there, and I think there are many principled people who are there now. Many of the people who came there, who work there now, certainly in the prosecution office, were not there in the early 2000s when a lot of the misconduct was underway. But they are kind of stuck with it, and so they can't really undo it. So I don't know. I mean, there are some people who think that the whole effort to create a parallel system is wrong, and they don't want anything to do with it. But I don't want to suggest that there's anything unethical about people who think they can make it work.
My question is, I'm just having spent time there and worked on this project. Can you envision a set of circumstances where we will ever close Guantanamo while there are still people living there in captivity? It just doesn't seem like there's any constituency at all for that. The president paid no political price whatsoever for promising to close it and then not closing it. And so, just doesn't seem like people care.
Well, this is one thing. There are certain kind of overlapping issues, and I'll get to that in a second. But one of them is that even though military commissions and military commissions trials, all the ones that we've had, have all taken place at Guantanamo, and these are sort of fused, as a legal matter, they're separate. In other words, the rules are and the laws as they're written mean that a military commission trial can take place anywhere in the world, on an aircraft carrier, inside the United States, outside the United States, on Mars. It could be anywhere. And secondly, the authority the government claims to hold people at Guantanamo is unrelated to whether or not people there committed any crimes. It asserts the authority to hold them as enemy belligerents, basically de facto soldiers, and they're being held under preventative detention to stop them from doing things in the future. And you don't need to have a trial and prosecute and convict them in order to do that. So in a sense, they're like overlapping legal regimes, but they don't necessarily have to be. In other words, you could close Guantanamo and still have military commissions, or you could junk military commissions and still have Guantanamo. Now, getting to the Guantanamo aspect of it, there are right now about 140 men, they're all men, who are there, and most of them have been cleared for release by either the Bush administration or the Obama administration, meaning that the United States concluded that they were captured and imprisoned in error, or they no longer are much of a threat, or weren't initially much of a threat, and they can go home, and there's no need to keep them there. But the reason that they are there has to do not with them, but with political and diplomatic issues in the United States and other countries. So most of those people who have been cleared for release are from Yemen. The United States doesn't think Yemen is a good place for them to go because it's an unstable country, and who knows what they might get mixed up in, so they can't leave for Yemen. The others have been cleared to really go to other countries, but the Congress, because it doesn't trust the president, decided that it was going to prevent the president from removing them from Guantanamo. So the Congress has imposed restrictions on the president removing people from there. And then you have the 30 or so people who have been charged or could be charged under military commissions, and they're not going to let them go because they think they have enough evidence on them having committed past crimes. And then there is the remainder, who are people who there isn't enough evidence to charge them with a past crime, but the government believes they'd be really dangerous if they were at large. And is there any thought that this group, with its three subsets, might ever get out of there? I sort of don't see it, because as you say, there's no political constituency for it. The restrictions on moving people out of Guantanamo were imposed by a Democratic Congress in 2009. When they were the president's own party. It seems that the only thing I can think of politically, because the president was not willing to spend any political capital, as they call it, on this, would be if he decides, as he starts looking over the plans for his presidential library and museum, and sees the whole Guantanamo exhibit and wonders, I don't know if I want future generations, walking through that thing, and seeing, under the disappointments or unkept promises wing of the museum, to have that thing there. So I suppose that if he's kind of going through the checklist in 2014, 15, maybe he will suddenly decide that's something he's got to do, particularly if his party takes the House of Representatives. But otherwise, it doesn't seem to bug. I mean, that's why it's sort of kind of like this sealed off thing. It's like he's not adding to it. He's not putting any more people in there. but the Congress is not letting him take anybody out. So it's just this sort of kind of like this Flying Dutchman of detention.
Do you think the increased drone warfare has kind of been a response to some of the issues that have come from Guantanamo Bay? By that I mean, do you think President Obama believes that there might be less repercussions from just assassinating someone because people tend to forget it after it happens, as opposed to having this constant reminder, like Guantanamo Bay, for arresting someone, bringing them to trial?
Yeah, that's a really good question. It's something that a lot. We've thought about. This even came up in the New York Times. Had some articles that kind of suggested this, recently, in which this sort of drone targeted killing program that started under Bush and has expanded under Obama, of like just killing suspected terrorists in Pakistan and so on, instead of capturing them and bringing them to the U.S. In the duty that a country has to an enemy or suspected enemy at large is much less than when it's already captured. So if there's an enemy out there, it is much more legally justifiable to kill them than if you've already captured them and disarmed them. To then kill them becomes more problematic. So there's been this thought that you just kill them. No muss, no fuss. We can move on, just like you said. The administration denies that's what it's doing, and I don't know that they've. I don't have any reason to think that they made a specific calculation about it. I mean, if you look at where the what they're doing, where are those drones active and where are they capturing people? Drones are mainly active where? In Pakistan, where there aren't U.S. ground forces. Yemen, where there aren't, supposed to be U.S. ground forces, parts of Africa, and so on. So you're looking at, I don't see that they are, they're not operating like in other countries where prisoners have been taken, like Abu Ghraib was found in Turkey and then sent to Jordan. So my guess is that it depends on where they think the suspect is. If it's somebody in Pakistan, they're gonna drone him. But if it's someone in a country that, say, has an extradition arrangement with the United States, whatever, they wouldn't. But it is possible that had the Congress approved the president's plan to close Guantanamo and use this prison in Illinois to house enemy combatants, there would have been a greater effort on capturing because they'd have a place to store them. Right now, there really isn't, and some, as they have occasionally captured people, they've held them on aircraft carriers and elsewhere while trying to figure out what to do with them.
Ask another question, but we have time for questions. What is your perspective as someone who's probably had more experience than maybe many of the people who are in Guantanamo now? What is the way forward? I mean, Lisa's question was about closing Guantanamo, but you described it as the legal Superfund side. And that could be a pessimistic view, but it could also be an optimistic view because Superfund does clean up stuff after a while. I mean, it seems as if they're really at loggerheads here, right? I mean, you've got these tainted defendants, evidence that can't be used. Even if you diminish the sentence, are they going to be, how is this all going to work out? Do you just say it's going to grind on? It sounds like some people are not even be brought to trial.
Well, I have to say that, when Obama took office, I thought it was much more likely that he would actually close Guantanamo than end Don't Ask, Don't Tell. So I was like totally wrong about that. Guantanamo turned out to be a much more attitudes have not changed on that. I really don't know. I'm sort of surprised that it's still there, and I think it's still there not because of any great constituency seeking to keep it there. I think it's more because it turns out to be just a politically damaging, career-destroying kind of black hole for anyone who goes near it. And so, as you point out, there's no positive effort to either close it or turn it into something else. It just, I mean, I think my impression from talking to people in the administration is that they just don't want anything to do with it. I mean, they just want to basically kind of wall it off and forget about it. And, you know, Congress has said, no, you can't close it. Fine, they can't close it. They've got to keep spending to keep it open, but they're not going to do anything to expand it. I mean, that's certainly one thing Obama does not want to do. He's not going to expand it, and he's not going to want to send more people there for trial. So it will just keep kind of limping along. I mean, my guess is that the best chance of there being any change there is if anyone actually starts, you know, adding up how much it costs to run that place, which is very, very expensive to operate. It is a very costly type of facility, and it is sort of amazing that. I mean, it costs millions of dollars each year for each of those prisoners. I mean, to me, it's kind of mind-boggling that 140 inmates, most of whom the U.S. says shouldn't be there at all, can absorb so much money and so much attention and so much of the so many resources that the United States, you know, has in its military and national security and political apparatus. So, you know, so now, of course, the people who are working on military commissions by nature, they're not going to want to think that what they're doing is just sort of a waste of time or a cleanup operation. I mean, they have dreams of expanding it and, you know, someday having untainted cases that they can prosecute and that kind of thing. I mean, they all, you know, we all have dreams, and they have them too. But I don't, you know, unless someone says, gee, unless some Pentagon planner says, we'd rather spend money on more drones, you know, or something like that, then I don't know.
Maybe not domestically, but when or where is there international pressure on Guantanamo for the U.S. to start closing or start doing something else with it?
Well, it's very unpopular internationally. And in fact, that was the reason that was one area in which both Obama and his opponent in 2008, John McCain, agreed. They both said they wanted to close Guantanamo, partly because it had become an obstacle diplomatically. That other countries viewed it as not a heroic aspect of the American story, and that in some parts of the world it was even, you know, a symbol that helped recruit militants opposed to the United States. Foreign governments, including those in the UK and, you know, other close allies, will not cooperate with Guantanamo prosecutions and will not extradite people who will be prosecuted by military commissions. So there is a law enforcement element in which anyone, for instance, you know, the UK extradited some terrorism suspects, I think last year, and they would have been, in theory, eligible for military commission because they were not U.S. citizens, but they're being tried in federal court, and they're quite clearly the UK, you know, indicated that they would not be sending anyone to go back to Guantanamo Bay or to be prosecuted outside of a federal court. I mean, they have some confidence in federal courts. The State Department has been the main entity in the government that's wanted Guantanamo closed because every time they go to hector some foreign country about human rights, they get Guantanamo thrown in their face. So they don't like having that as getting in their way. So yeah, there is diplomatic pressure, but, you know, how serious pressure is it? I mean, no other country is going to break relations with the United States or stop doing something it sees as in its own interest because they have some objection to Guantanamo Bay. So I mean, it's one of those things that mainly would show up as a domestic argument saying, let's get rid of it because it makes it harder for us to deal with, you know, other countries in terrorism investigations because they don't want to cooperate with it. You know, they don't like it.
Could Obama pardon these people who you decided shouldn't be there? Would he be allowed to do that in the face of whatever congressional laws preventing him from releasing them?
Yeah, I would say just after he makes a speech confessing to be a secret Muslim who was placed there by Osama bin Laden, to destroy America. I think right after he makes that speech, he will then pardon people at Guantanamo Bay. I mean, I don't. Yeah, I mean, they haven't been convicted of anything, so there's nothing to pardon. He can't. The issue is that Congress has cut off funding for transfers. So the same mechanism that they used to stop funding of the Contras in the 1980s in Central America and to stop the Vietnam War in the 70s. They have used to stop Obama from transferring people out of Guantanamo. So I don't know that there's anything he can do, and I also would expect that if anyone there is eventually transferred out, and some were transferred out under his administration, he would describe it as a complete professional decision by the national security apparatus that he had no personal nothing to, if that goes wrong, man, it's not his doing. That's those people who they are paid to take the fall, not me. So yeah, I guess possibly, but I wouldn't expect that as the outcome.
Well, here's the habeas corpus appeals of the detainees.
That's a good question. In 2004, the Supreme Court, in a case called Rasul, said that habeas corpus applies to Guantanamo Bay, meaning that inmates there can challenge their detention as unlawful. Congress tried very, very hard to strip that right from them through statutes, and in two subsequent cases, the Supreme Court eventually held that there's a constitutional habeas right that applies there. That was in 2008 in the Boumediene case. Those habeas claims are heard in the U.S. District Court for the District of Columbia, and then on appeal to the D.C. Circuit Court of Appeals. The D.C. District Court has ordered a number of detainees released, basically said that the low burden the government has to meet to justify holding someone as an enemy combatant, which is not the same as convicting them of a crime. I mean, they just need a preponderance of evidence, and they have a very deferential standard in habeas claims. There are a number of detainees who the district court has said the government hasn't met that burden. In every instance where the government has appealed, they have gotten those decisions reversed or vacated. So D.C. Circuit has basically given the government everything it wants. So, and there had been some expectation that the D.C. Circuit opinions, which are very, very, some of them in particular, very hostile to the Supreme Court's rulings on Guantanamo cases that basically accuse the Supreme Court of being in error, which is not typically the posture of a lower court, that would almost inflame the Supreme Court to review one of those decisions, but so far they have not done that. So right now, yeah, those habeas claims go to D.C. District Court, then get vacated by the D.C. Circuit.
We have time for a final question?
I apologize if you already said this, but
I did.
what about access to Guantanamo? If an American journalist or foreign journalist wanted to get there or get access to there, is there any access at all?
Yes. In fact, there has been from the beginning. Now, it is a limited kind of access in that you can only see what they want you to see. But I was there actually in January 2002, not for the first shipment of prisoners, but one of the first ones, and you saw them offloaded and from the C-130s and so forth. And I've been there many times since. At present, there are two ways to go if you are a journalist. It depends if you're going because you're interested in military commissions or if you're interested in the detention in general. It's actually easier to go in some ways for a detention in general tour because that's operated by a different unit of the military. I mean, the military has many units that do different things and don't, even if it may seem like they're doing the same thing, they see it very differently. So the detention camp public affairs unit will conduct tours and will bring journalists, and it's mainly been foreign journalists who've been interested in doing it. There are a lot from foreign countries who wanted to go and tour the facilities there and do reports. Much less interest from American journalists. If you're interested in covering a military commission proceeding, you've got to wait till there is one. There's one coming up, as I said, on April 22nd, and this is a new Obama-era rule. If you go there to cover military commissions, you cannot get a tour of the detention camps. Now, it used to be in the Bush era, for some reason, if you were there and there was like downtime one morning, there were reporters wanted to go see the prison camps, they would do it. But now no, you're here for commissions, you can't go and see the camps, or you're here for camps, can't see the commission. I mean, I don't know why. You also can do something else, which is which I think is a significant increase in transparency under the Obama administration, which is that you can watch military commission proceedings here on the mainland. The administration, after years of badgering by the press, agreed to set up a closed circuit site. So if you want to watch any member of the public, you don't have to be a reporter. If you go to Fort Meade, Maryland, which is just outside Baltimore, you can go and you can watch the closed circuit feed of the hearings, and you can see Khalid Sheikh Mohammed and Ramzi bin al-Shibh and these other guys, and see the prosecutions and so forth right there on the base. So that is another way. And actually, most of at least the newspaper reporters, I mean, when they cover to the extent they cover them, that's where we tend to do it from, because it's a real drag to go to Guantanamo Bay. It takes up a lot of time, and it's not, you sleep in a tent, and your movements are constrained, and it's difficult to make phone calls. It's not that. On the other hand, the snorkeling is not bad. So you take your lumps. But yeah, you can go now. They're on a hunger strike, and at the moment the prisoners there, and I heard that the military has clamped down on access to the camp more than usual. So I don't know what it is right now, but in general, yeah, you can go.
Thank you very much for your time.
Well,